Hello, everyone, and welcome to Uncivil Law, where, as always, we learn through the misfortunes of others. I am your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the United States Supreme Court, and we are here with your legal news roundup. All the legal news happening in your world so that you might be better legally informed. We begin with Elon Musk and his takeover of Twitter/X. Revenue has been a bit of a problem for the brand, as he spent $44 billion on an asset that was not worth it and having some difficulty bringing in revenue to justify the expenditure. Elon Musk is threatening to sue the Anti-Defamation League for defamation, which is just, the greatest irony possible, blaming the Anti-Defamation League after slumping sales at X for calling him names. So we're going to look at a little bit at this lawsuit, take a little bit about the law. Let's learn a little bit more about this. Elon Musk has threatened to sue the Anti-Defamation League for defamation on Monday after blaming the nonprofit for advertising revenue slump on the Twitter/X after the takeover of the platform. Musk accused the Anti-Defamation League in a post on X of trying to kill his platform by falsely accusing it, the platform, and me, Elon Musk, of being anti-Semitic, after the nonprofit reported a spike in hate speech on the platform following reinstatement of banned accounts there. So first of all, the dispute over whether or not there's more hate speech is, of course, real. The data is mixed at best on that. And part of it is like, what speech should be allowed and what speech shouldn't be allowed. And anti-defamation over here is like, we want you to engage in more censorship because we don't like the speech. And Elon Musk is like, but I like, freedom of speech. And so it's like, we're going to accuse you of being an anti-Semite for not accommodating to our wills because you're allowing speech we don't like on your platform. So that is some of the dispute happening around that. Elon Musk has said that advertising revenue is down as much as 60%. He claims primarily due to pressure on advertisers by the Anti-Defamation League, according to what advertisers tell him. So they're almost succeeding in killing the X. So the idea here is restraint on trade and tortious interference with prospective and current economic advantage. That ADL is trying to interfere with the economic advantage of Twitter by putting pressure on these third parties and by making up lies. So that is what they are saying is happening. Musk said in another post before threatening to sue that he's pro-free speech, but he's against anti-Semitism of any time. Elon Musk writing, if this continues, we'll have no choice to file a defamation suit against, ironically, the Anti-Defamation League. If they lose their defamation suit, we'll insist they drop the anti part of their name, since obviously laughing emoji. I mean, that is pretty fun. So the Anti-Defamation League, of course, has been a left-leaning player for many, many years, and trying to say the speech that he has the hate speech, which is the speech they don't like, which, by the way, incidentally, not for nothing, is not defamation, just, incidentally. Defamation of large groups isn't a thing. You can't defame large groups of people. They have to be individual people. If you have a small enough group, then maybe you're talking about the individuals within the group, but, not so much when you're talking about any group of any real size. So, yeah. The Anti-Defamation League, for its part, published a report in May that found over 5,000 examples from February of virulent anti-Semitism from as many as 2,100 different accounts that were restated under Twitter, which to my mind doesn't sound like a lot to me. I mean, 5,000 examples from 2,100 accounts. So on average, they're doing like a little bit more than 2 a piece over the course, since May. So, over the course of 4 months, that maybe they did an anti-Semitism in their view twice. I mean, it doesn't necessarily sound like a huge problem to me, but, that's my assessment of the thing. And certainly seems odd to say that this is evidence that Twitter or X or Elon Musk as a whole is anti-Semitic because of, what a few random jerks say. On Saturday, Musk responded to the right-wing campaign to ban the ADL, saying maybe we should run a poll on this. The ADL has long been a craw in many people on the right's side because many people on the right do not believe the Anti-Defamation League is really pure and full of light, that they are doing things that are, in furtherance of left-wing views and left-wing agendas, not really trying to promote, kindness and love, but only prefer things. So not particularly a surprise that there's a right-wing campaign to go after the ADL, and Musk, of course, adding his 2 cents in, saying maybe we should run a poll on it, which would be kind of hilarious if it winds up being the Twitter versus the ADL. That could be fun to watch just for the spectacle of the whole thing. X is also currently suing the Center for Countering Digital Hate, accusing that nonprofit of making false claims, saying it had bigoted speech had surged on the platform since the takeover in October because the data at best is ambiguous. ADL, for its part, said, quote, ADL is unsurprised, yet undeterred, that anti-Semites, white supremacists, conspiracy theorists, and other trolls have launched a coordinated attack against our organization. This type of thing is nothing new. So it must be that they're white supremacists. It must be they're conspiracy theorists. It must be that they're anti-Semites because they oppose the ADL. It couldn't be to any other legitimate reason. It must be that they're horrible, horrible people. Only horrible, horrible people oppose the ADL. You're not a horrible, horrible person, right? So surely you don't oppose the ADL. I mean, you don't want to be on the same side as a white supremacist, do you? No matter what your reasons are, do you? Do you? Yeah, painting everyone with that big ass brush. We know what you're doing. They also say that the onslaught comes following our participation in the 60th anniversary of the March on Washington, where ADL marched proudly shoulder to shoulder with African American leaders and those from other minority communities. It also follows a meeting with the leadership of X that clearly upset these hateful groups. Again, it must be the hateful groups. No one else could have a problem with us, the ADL. We are a virtue of beacon and light and joy. No one could have a problem with anything we do or any positions we take. It must be that they're hateful groups because they don't like us. That must be the problem. The ADL continuing to write, such insidious efforts don't daunt us. Instead, they drive us to be unflinching in our commitment to fight hate in all of its forms. Well, you want to look in the mirror a little bit on that one, my friend, and ensure the safety of Jewish communities and other marginalized groups. Ensure their safety how? Ensure their safety by leading to suppression of speech, by the censorship, by making sure that only your preferred views get said out loud. That might be a bit of a problem. That could be a bit of an issue when it comes to freedom of speech. Thus, that brings us to the end of the story for the moment about Elon Musk threatening to bring on a suit to the Anti-Defamation League, which I don't know if that can be successful or not. But the fact that the Anti-Defamation League is putting pressure on third parties, especially to the extent the Anti-Defamation League is communicating with any of those third parties directly and directly telling them or putting pressure on them to cancel contracts or not engage in contracts, that might be tortious interference. So I'm not so sure about defamation because broad-based claims like anti-Semite usually aren't actionable. Under US law, you usually need something a little bit more specific because something like calling someone an anti-Semite is generally deemed too general to be actionable because what makes someone an anti-Semite is generally too unspecified. So you need something more specific. But maybe based on specifically what they're telling the third parties or specifically how they're interacting, maybe there's defamation in there and also maybe some sort of tortious interference. So a lot's going to depend on the specifics of exactly what the ADL is or is not doing. Elon Musk threatening to throw down the gauntlet, so we'll see. At least for a moment, that brings us to the end of discussion of this story. All right, good morning, Uncivilians. How are you doing today? I am glad to be here with you. I hope you're glad to be here with me. It has been a little bit since we've done a weekly news roundup. We have been drowning in the Ken Paxton impeachment trial, which has also been very hard on Uncivil Law's workout. But Uncivil Law's happy to say he was back in the gym yesterday, and he did a nice workout, and he posted the results this morning. So if you go to my community tab, you can see the workout that I did yesterday, because I got around to posting it finally. But, you know, one of the things I have to figure out sort of in a going forward way is how to deal with these particularly long trials when it does the workout, because, you know, they don't give you a lot of time. Usually they give you maybe an hour and a half for lunch. It's like, it's not enough time really to really do anything. So, well, you know, go early in the morning, wake up at the break of dawn, go after the streams end. These streams were brutal though. They were starting at 9 and going to 7, you know, so they were like a long day, man. So how to make that work with the workouts, still a little bit to be figured out, but hey, we made progress by getting back to the gym yesterday, and that is a good thing. So I'm pleased about that. I'm also pleased that we had a nice time in Nashville, and I was happy to meet some of you there in person. It was an interesting event. Once again, Nick had a very successful event. I would be guessing that he had about 150 people there, give or take. Something in that neighborhood, I think, probably showed up to visit him and spend time with him and listen to his show. It was an interesting show. It was not my style, right? Because Nick has multiple facets to his personality, which I appreciate. But the show was more raunchy and MGTOW-y and more divisive and offensive humor, almost for its own sake, which, you know, that's fine. It just literally was not for me, but I had a fun time meeting people at the event, notwithstanding the thing, and it was always nice to see my friend Nick and see that he's thriving so well, which is appreciated. I also wanted to just comment very briefly again on the Ken Paxton impeachment trial. I think in the end, I'll simply note this, that I do not think that if everything were exactly the same, but Ken Paxton were a Democrat, the vote in the Senate would have been the same. I'm just guessing. I'm just guessing that the votes in the state Senate would not have been the same had Ken Paxton been a Democrat, but there were no other differences in the case. So if you agree with that conclusion, then you agree with me that it was political, which again, isn't to say that it's illegitimate, because the process is inherently political. It's supposed to be political. It's an impeachment. It's political. But it is to say that the judgment in the end was political, which again, isn't to say invalid, just taking note. So, yeah. I was listening to some of the speeches a little bit by some of the legislators after the impeachment trial. And I was like thinking to myself, if Ken Paxton had been Democrat, I would imagine that the talking points would have just flipped. You know, the Democrats said, this is a travesty. The evidence was so obvious. You know, that would have been the Republican talking point. The Democrat talking point would have been exactly the opposite. So, what can you do? All right, let's do another one. Speaking of political processes, which I'm sure everyone who thought the evidence against Ken Paxton was shaky or non-existent will bring those same rigorous standards to this case. I have no doubt, right? They wouldn't be duplicitous, right? They would bring that same level of incredulity, that same level of demanding of only the most serious proof, the people who were voting for Ken Paxton, right? They will surely bring it to this case, right? In impeachment news, the GOP is holding its first impeachment hearing next week, subpoenaing Hunter Biden's bank records. So perhaps unsurprisingly, it seems like we're just going to impeach every president going forward now. That's just what we're going to do, right? We started with Clinton, and then of course we impeached Trump twice, and now we're going to impeach Biden and probably impeach whoever's next. So impeachment is just another part of the job description, I guess. So of course, they are going to look for bank records and other records that suggest who Hunter Biden may have been giving money to and who the big guy is. And I'm sure the evidence will be evaluated in a completely politically neutral way by all sides. Let's learn more about this. The House Oversight Committee will hold its first hearing into an impeachment inquiry into President Biden on September the 28th, also announcing plans to subpoena bank records of the son, Hunter Biden, as soon as this week. So yeah, I'm sure. This will also be noted that, of course, the House Speaker just declared that there will be an impeachment committee, something that the Republicans themselves criticized Nancy Pelosi for doing by just declaring an impeachment committee, but now they're going to do it too. So I suppose they criticize and then they just do the same thing. So, okay, we're doing that now. The hearing will focus on constitutional and legal questions surrounding the president's involvement in corruption and abuse of public office, according to the House Oversight Committee. When asked if the hearing would reveal new evidence, the committee chair said the hearing is not expected to cover new ground and took a dig at the media. Okay. Well, I think some of you need to have a refresher course on existing evidence, so I'll probably rehash some of that if for no other purpose than to help educate Washington. That is not particularly encouraging. That is not especially encouraging. So even the guy who's running it says, we don't expect to uncover any new evidence. We're simply going to rehash the same evidence that's already been in the news. That is not particularly encouraging about this process. While Comer says he believes President Biden accepted a bribe as part of his dealings in Ukraine as vice president, the GOP has yet to find a smoking gun to back the claims, which, they may or may not ever find, depending on how clever things were organized. The lack of new evidence for the hearings will no doubt be a target for Democrats. Yeah, I would think so. If you yourself are saying the hearings are not going to uncover anything new and just simply rehash what's in the media, then, to some degree, what's the point? They say the committee has failed to connect President Biden to any wrongdoing. The committee has also said it would subpoena Hunter Biden's bank records along those with his brother James Biden, the president's brother, which, maybe if they're able to get access to those bank records, and I imagine there'll be a hell of a fight over that too, right? You're not a real committee. You can't get access to the bank records and blah, 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 right? They're going to subpoena, there's going to resist it, there's going to be a court fight over it. It's going to be a whole thing trying to get it, and then they'll get access to the bank records, and it probably won't tell them what they want to know in the end anyway, if there was any cleverness about this at all. The crux of the GOP claims relate to President Biden's effort to oust what the U.S. said it viewed as a corrupt Ukrainian prosecutor, but the Ukrainian prosecutor was at the time investigating Burisma, to which Hunter Biden was directly involved. And so they said, it's a corrupt prosecutor. It has nothing to do with the fact that they're going after someone to which my son is directly involved. That was the claim, at least. But yeah. Republicans have claimed that then Vice President Biden accepted a $5 million bribe in exchange for helping to oust the Ukrainian prosecutor, whose name was Viktor Shokin, over investigation into Burisma, the Ukrainian gas company where Hunter Biden was at the time a member of the board, despite the fact that he has no particular skills or education or other qualification in any sort of trade or discipline that would enable him to be a member of a board of a gas company. He doesn't have any particular education in this field, no particular training, no particular experience. Why ever would he be a member of the board of the Ukrainian gas company? Well, Hunter Biden himself said it had a lot to do with his last name, which might be a bit of a clue. But then again, that's something that we already know. So what is the House going to do now? President Biden's actions were in line with other calls from other world leaders at the time. So yes, that's fair. And then it goes into your, why did you do it, right? Did you do it because he was really corrupt? Did you do it because other leaders had labeled him as corrupt? Did you do it because of the corruption? Or did you do it for your own self-serving needs? What is your motivation behind the thing? There are legal reasons and there are unlegal reasons. Which one did you do? And so, well, let's take a look at it, right? But, yes, there is evidence that would suggest legal reasons, including the fact that other world leaders had a problem with this person. The unverified claim of the $5 million bribe came from a confidential source to the FBI, someone the Bureau considered credible even as they were unable to corroborate the tip. The source relayed a conversation with Burisma head and noted that exaggeration and bragging about paying off politicians was normal among Ukrainian businessmen, which, to be fair, that is not completely an invalid idea. Bribery is unfortunately somewhat a part of the world in many parts of the world, and it might not be unusual for people to say that they did more than they really did to make themselves look better. Look how much I was able to get done. I'm the best briber ever. In some parts of the world, that's something you can brag about. So the fact that he might have been bragging and making things up or exaggerating isn't wholly without merit. The House, for its part, said that they see Hunter Biden's bank records as a key way to advance their probe. Everyone in America knows why we need the bank records, and they are going to provide them or we'll see them in court. Well, they're going to see them in court. For 100% they're going to move to quash the subpoena, and there's going to be a whole fight about whether the House committee is legitimate or not, because the House Speaker merely created it out of thin cloth. And the Democrats are going to say you can't do that, and the Republicans are going to say you did, and the Democrats are going to call them hypocrites. And we all know how it's going to end. So, and then they'll get copies of the bank records, and it's probably unlikely that they'll say what they say, because there's probably not a line item that just shows direct deposit from one account to another. I'm guessing they weren't that sloppy, but you never know. Sometimes people get complacent. So we'll see if they ever get access to the bank records, although I don't have extremely high hopes they're going to reveal, the smoking gun. Thus, that brings us to the end of the story about GOP holding the first of impeachment hearings next week. And I'm sure everyone will look at this in a perfectly neutral way, and no one will flip sides and no one will take positions other than what they took in the past. Everyone who took positions, about past impeachments will continue to hold those positions. There will be no duplicity, and we'll just treat this just like any other case, right? The party of the person doesn't matter. What matters is the truth, right? Right? Probably not. Probably going to be political. But the House has already said they don't expect to find anything new, which isn't encouraging. So we'll see. At least for a moment, that brings us to the end of discussion of this case. All right. Let's see what else we got today. All right. In a good offense is as good as a good defense news, Hunter Biden has filed a lawsuit against the IRS and said that and there's a dispute about why, right? Some people saying that's merely a smear to try to discourage whistleblowers. So, when people are attacking you, maybe you try to attack them. So Hunter Biden going on the offensive, suing the IRS. Always super fun. Let's learn a little bit more about this story. An attorney for one of the Internal Revenue Service whistleblowers who cried foul on the Justice Department's handling of Hunter Biden's influence peddling and tax investigation called the First Son's new lawsuit against the agency a frivolous smear. So some people who are whistleblowers, or are they whistleblowers? Maybe they're not whistleblowers because we've had a whole bunch of disputes about that recently. But what does or does not make someone a whistleblower? So are they whistleblowers or not? Right? So that might be a little bit in the eye of the beholder. And they say, hey, we can't help noticing the IRS seems to be doing things in a way that might be, a bit of favoritism towards Hunter Biden. So we're going to make a report about it. And now Hunter Biden wants to sue the IRS, basically for saying, mean things about him and trying to defame him, I guess. So fun. Hunter Biden's attorneys alleged that the IRS agents, rather than being actual whistleblowers, have merely targeted their client and sought to embarrass him, demanding $1,000 in damages for each unauthorized disclosure of the First Son's tax returns. So, of course, tax returns are to be kept confidential, and they say that you exposed our tax records not for any legitimate reason, but merely because you're salty and trying to do this for, reputational damage. And you weren't authorized to leak that stuff. You're not whistleblowers, you're bad faith actors. That sounds familiar. Yeah. Mark Littell, an attorney for one of the whistleblowers, an investigator who testified to Congress that Wilmington U.S. District Attorney's Office was different than any other case in his 14 years of public service, told that the Fox News to sue his attempt to frighten others. Hey, I've been working for a long time and I couldn't help noticing the U.S. Attorney's Office was treating this case differently and specially. They were acting in ways that were abnormal. They were acting in ways that seemed odd to me. They were acting in ways that differed from my 14 years of experience. I made a whistleblower report based on my observations about how the office was acting in this case differently. It seemed to be based on political favoritism. Yeah. Are they whistleblowers or not? Depends on whether or not you like the Bidens, I guess. This lawsuit is just a frivolous smear to try to block the whistleblowers or any potential whistleblowers from coming forward. There are no vessel violations. The whistleblowers followed the statute. So they say, aha, we followed the statute. We followed all the elements. We made a report in good faith to the relevant law enforcement authority. So and we did it based on our observations that the U.S. attorney did things in a way that seemed abnormal, in a way that seemed to be politically favoritism. And we made the report, and now they're suing us, saying that we were, not really whistleblowers. We're just trying to make them look bad because we don't like them politically. Yep, same story, different day. Lytle cited how Shapley's testimony and that of a fellow agent essentially led to Hunter Biden's sweetheart plea deal being exposed. In the end, a judge rejected the plea deal, and the Attorney General ultimately appointed the lead Delaware federal prosecutor, David Weiss, special counsel in this case, which means that he has the ability to bring claims on behalf of the United States anywhere within the United States rather than just merely in his district. So he has the power to act completely independently and not go through the normal chain of command and file a lawsuit or criminal complaint on behalf of the United States anywhere that he wants. So he got his special counsel status, and he recently filed charges for the gun violation, which, is also ongoing. In response to these developments, Lytle claimed Hunter Biden and others are deciding to come after the whistleblowers. Although, of course, it's noted that it's not against the individuals, but rather against the agency itself for allowing and facilitating the whistleblowing and allowing the information to become exposed, potentially in violation of law. Lytle argues tax disclosures were each legitimately protected by law, adding that Shapley and Ziegler encountered numerous steps wherein investigators slow-walked or blocked junctures that could have potentially led to President Biden. I can't help noticing that, that the investigations seem to be slow-walked. I can't help noticing we're acting in ways that are abnormal in a way that benefits the Bidens. I can't help noticing that leadership doesn't seem particularly interested in pursuing these cases. The leadership, who is our bosses, seem to not want to pursue these cases. I think that there's a problem. They're acting in ways that are abnormal to our normal processes. They seem to be acting in a case, they seem to be diminishing the importance of this case for political favoritism reasons. I'm going to make a whistleblower report based on my 14 years of observations. This is outside the norm. Do we approve of this or do we not approve of this? How do we feel about this? Former Twitter file journalist Matt Taibbi, who disseminated information pertaining to the Hunter Biden laptop saga and alleged federal interference therein, created shockwaves last year, calling the lawsuit itself ironic in a separate interview on The Story. It's certainly ironic, isn't it? It seems like the government bent over backwards to keep a lot of information that was clearly newsworthy out of the public domain as a result of a variety of things, including censorship of the story. We didn't learn for a very long time through these whistleblowers that there were a whole galaxy of shell companies that Hunter Biden was tied to. So the whistleblowers making reports that are exposing internal information that's on the tax records that are supposed to be secret, because they thought they didn't approve of the way that their bosses were doing the job by slow walking the case and trying to prevent them from asking questions they would normally ask. They were directed by their boss to not take certain actions they thought would be prudent. And so they're like, I see a problem. Maybe I should report it to somebody. Taibbi said it's difficult to understand how Hunter Biden could claim the tax information revealed by investigators is a violation of personal property when the data is relevant to a major legal probe. Well, that's really not that hard to understand because tax records are supposed to be secret. And so when those records get exposed, that could be a problem. As soon as federal agencies start behaving like independent entities, of course they become enemies of Hunter Biden, he added. That's certainly ironic. I mean, again, the evidence shows they bent over backwards to try to accommodate him, even when he said ridiculous things, like trying to indicate his income was a loan, when clearly it was a taxable event as soon as he gets it. They hide stuff, and now they've come out that they're upset about it, and that's what the lawsuit is about. Thus, that brings us to the end of the story for the moment about Hunter Biden's lawsuit against the IRS, claiming that the whistleblowers weren't really whistleblowers because, they merely disagreed with the directions that their boss told them to do. And their bosses have power to make those choices. So they aren't real whistleblowers. They just made a decision that they knew better, and they made a report to higher ups because they thought, based on their 14 years of experience, their bosses were acting in ways that were political favoritism. But of course, their bosses have the power to make the decision, or do they? So that's part of the interesting issue about the whole thing. And he's suing, saying the IRS has engaged in a frivolous smear. So we will see how that all progresses. At least for a moment, that brings us to the end of discussion of this story. Great. All right, let's do another one. Where are we? What the hell is going on? In illegal immigration news, a video has been released showing the Border Patrol releasing hundreds of illegal migrants onto San Diego streets saying merely "you're free." So the Border Patrol has these people, they are illegal immigrants, they are not here legally, and Border Patrol's like, well, we caught you, but we how would you like to just be in the United States now? Just simply setting them free to go anywhere they might like to go. Perhaps they'll go to New York, right? Because New York is a sanctuary city, right? All right, yeah, okay. So let's learn a little bit more about this. A new video has been released that shows Border Patrol releasing hundreds of illegal migrants onto the streets of San Diego. 3 unmarked white Border Patrol buses can be seen pulled over to the side of the road as it began releasing, 3 unmarked white Border Patrol buses can be seen pulled over the side of the road as they begin releasing hundreds of migrants onto city streets across from a transit terminal, according to a video obtained by Fox News. Some of the migrants on the buses were from China and Pakistan, so not merely people crossing the Mexican border. People here perhaps came here through other means and had been obtained or detained by Border Patrol, say, haha, you're here illegally, but haha, let's just release you into the United States. In one notable exchange between a migrant and Border Patrol agent that was caught on video, the Border Patrol agent said, "You're free to go on and do whatever you want," the Border Patrol agent said. The migrant asking, "It's no problem if I go to Chicago?" The Border Patrol agent responding, "You can do whatever you want. You're free." It makes you wonder a little bit why we have Border Patrol. What's the point? We caught them. They're illegal. And now we're like, okay, you're free. You want to go to Chicago? Sure, Chicago sounds like a great place. You go to Chicago, you can do whatever you want. I have some questions when it comes to our border policy and what it means to be illegal at this point. Customs and Border Patrol, for their part, apparently thinking that this solves the issue, said the drop-offs are standard process. They're reportedly a way to relieve crowding at border crossings. So Customs and Border Protection's defense is, we do this all the time. This is just standard practice. I don't know why you're raising the issue. This is something we do every day. We just let the migrants off. We drop them off somewhere in the United States and we say, go wherever you want. Why are you upset? We do this every time. This is just the norm. What is the issue? Yeah, I'm not sure that really helps. Migrant releases are also happening in Arizona south of Tucson as well. In Sierra Vista, a Guatemalan migrant family was dropped off by Border Patrol in a Dollar Tree parking lot, leaving them confused about what they're supposed to do next. So Border Patrol just drops them off at the Dollar Tree, be like, good luck to you. Just do whatever you want. Okay. Apparently we have a very generous catch and release policy by Border Patrol. The local Arizona sheriff, for their part, slammed Customs and Border Patrol for releasing migrants on the street by saying, people come here from all over the country to smuggle here, endanger this community, the citizens that work to combat that. Then yesterday, Customs and Border Patrol is doing street releases, as they call them, safe, but there's nothing safe about them. In El Paso, the Texas National Guard is trying to use razor wire to keep a large group of migrants from crossing the border illegally, leading to further disputes with the U.S. government. Because, Texas has, the majority of the border with Mexico. And so, it's like, well, we can't help noticing they're trying to come to Texas because, we're right here and we would like to stop them. And so they're desperately trying to stop them and will lead to further fights with the U.S. government, I'm sure. Custom and Border Patrol, for its parts, estimates there were 230,000 migrant encounters in August alone. 250,000 migrant encounters in 1 month. That seems like a lot. That seems like a lot of illegal immigration. What are we going to do about it? Apparently, we're just going to get them on buses and release them wherever we want. In July, Border Patrol encountered 183,000 migrants, including those who presented at a port of entry. Meanwhile, major cities are struggling to handle tens of thousands of new migrants streaming in from the border. So all those places that said, we're sanctuary states, we don't like the deportation, come here, suddenly beginning to have problems with their own policies because they realize that, hey, wait a second, this is putting a burden on our communities. Why can't they remain in Texas? Why do they have to come here to the sanctuary city? They weren't supposed to come here. When we said come here, we didn't really mean it, but now they're here. New York is trying to absorb more than 113,000 migrants who have shown up in the city since the spring, 60,000 of whom are being housed on the city's dime with no end in sight. New York City suddenly having problems with the illegal immigration. What are those people in Texas upset about? Illegal immigration is great. We're a sanctuary city. Come to New York. And 100,000 of them do. And it's like, wait a second. We don't have the resources to deal with this. Maybe they should stay in Texas. And why is this Texas's problem again? Yeah, why do you want to just shift the burden onto someone else? Yeah, maybe we should not let them in the United States at all. The city apparently has spent more than $1.2 billion on migrants so far and is projected to spend up to $5 billion. The mayor, for their part, apparently ultra right-wing MAGA mayor Eric Adams of New York, said the issue will destroy New York City. We're getting 10,000 migrants a month. Every community in the city is going to be impacted. Well, that sounds like some far-right, ultra-right MAGA talk to me by the mayor of New York City, Eric Adams, who apparently thinks that migrants are not just a universal blessing and might pose a burden on the city of New York. Wow, I didn't expect the mayor of New York City to go far-right MAGA, but apparently when, the burden actually comes their way, they realize that maybe the burden wasn't all it was cracked up to be. The Chicago, for its part, has also seen an influx of about 13,000 migrants recently. The country's third largest city has already spent $250 million on the issue. Chicago Mayor Brandon Jackson is facing pushback from mayors of the city council over plans to house the migrants. So apparently, it's the city council of Chicago that are the ultra-right MAGA. The ultra-right MAGA city council of Chicago not happy that they're spending money on the migrants. I thought the migrants were a source of joy and love. And to try to keep them within their own country was hate and racism and xenophobia. What happened to all that? City Council of Chicago and far-right mayor of New York. The situation has sparked tension between Democratic governors and mayors and the Biden administration, with local leaders pleading for more help with let me redo this line. The situation has sparked tension between Democratic governors and mayors and Biden administration, with local leaders pleading for more federal help with the migrant crisis. I do very much enjoy watching Democrats get the back end of their own policies. It's like the Republicans told them. We warned them. We told them this was going to be a problem, and they just ignored us. It's like, you're a bunch of racist xenophobes. We told them, we tried to warn you. I do enjoy the schadenfreude of watching the far left get eaten by their own policies. It is fun. Thus, that brings us to the end of the story about Border Patrol releasing another couple, 100,000 migrants just, into the border with no direction, nowhere to go. Just, you're free to go wherever you want. And so apparently they're just going to wander the United States and go wherever they want. Maybe they'll go to New York City, where apparently the mayor of New York has turned MAGA, or apparently Chicago, where the city council has apparently turned MAGA. Or maybe to California. I'm not sure about their MAGA status, but I'm sure they can't be far behind. As all these far left cities who are like, to oppose the migrants means that you're xenophobic bigots, realize that, hey, wait a second, there's actually cost to us. Cost? We're not supposed to return cost. We were merely virtue signaling. You weren't supposed to actually take advantage of it. Yeah, they're taking advantage of it. And so this is happening with the people being released. And I don't know why they're not being deported or why we're not taking better efforts to, seal up the border, but that's where we're at because, the Democratic administration doesn't want to actually solve the problem for some reason. And at least for the moment, that brings us to the end of discussion of this story. Great. Okay. What else we got? The New Mexico governor thing is kind of old story at this point, so I'll skip that. All right, let's cover this one. They decided to take this case yet? Hold on. I think I'll skip that one because it's about a case going up to the Supreme Court, but they haven't decided to take review yet. This is a case dealing with whether the dog, by putting their paws in the car, committed a trespass, and someone decided to ask the Supreme Court for review, but they haven't taken it yet, so I'll skip it. Let's do a true crime one. This is from Florida, but not Florida Man. So we'll do a Florida case that isn't Florida Man because I have another case for Florida Man. Okay. In fratricide doesn't prevent me from being close to my brother news. A Florida man who fatally stabbed his brother for trying to evict him decided to sleep with his dead body laying nearby. Well, we couldn't be together in life, but maybe we could be together in death. I mean, you're a lot, more compliant now that you're dead. So I'm just going to sleep with you with your body laying nearby. And, that will bring us closer together. So we will be a family one way or another, no matter what happens. Let's learn a little bit more about this brotherly animus. A 61-year-old man in Florida was arrested this week after allegedly killing his 63-year-old brother, stabbing him to death because the older brother had begun the process of formally evicting his younger brother. And it's like, but I'm your brother. You're not supposed to evict me. We're supposed to be close together. And then he's like, I don't see that way. We just don't get along. And how do we resolve this issue? With a little stabbing. Donald Stephen Burberry was taken into custody Monday and charged with 1 count of second-degree murder, dangerous and depraved without premeditation in the slang of Edgar Ernest Derby, according to Law and Crime. According to a press release from the police department, the officers at about 9 a.m. responded to a call requesting a welfare check at a residence in the 300 block of Pembroke Pines, Florida, about 20 miles north of Miami. Upon arriving at the address, first responders say they discovered some unusual circumstances that caused them to go inside the home but didn't specify further. So it's a little bit unclear at this time whether or not they had probable cause to enter the house legally. So I suppose that could be an issue for a suppression hearing for another day. Why did you go into the house? But they saw something that was perhaps amiss. What was amiss? What did they observe? Unclear, but they decided to enter the house. Upon entering the house, they say they found an adult male, later identified as Edgar Derby, who appeared to have suffered multiple stab wounds and was pronounced dead on the scene. Officers continued to search the residency and soon discovered another adult male, later identified as Donald, who was asleep in his bed. So police come to the home. For whatever reason it is, they decide to enter the home, unclear. So we'll let that Fourth Amendment issue go by for the moment because we don't have enough to talk about it. They enter the home and they're like, we can't help noticing there's a dead guy here. I wonder who else might be in the property. There's this sleeping guy here. Maybe sleeping guy has some information he can offer us as it relates to dead guy. Our initial investigation revealed the two males located inside the residence are brother. Following an extensive investigation, Donald Derby was taken into custody for second-degree murder. The incident was determined to be isolated and domestic in nature, and at no time was there any threat to the surrounding community, according to the police. Pembroke Pines Police Major Al Zerkes told Miami affiliates that investigators believe the motive for the killing involved a dispute. Further explained the dispute involving Edgar notifying Donald that he had 24 hours to vacate the residence, which was owned by Edgar since 1999 and where Donald had been staying since 2021. So unclear what had recently, gone wrong in their relationship. But apparently after living there for 2 years, he said, you got to get out within 24 hours, which, not necessarily great. And he might have been able to resist that legally, because he'd been there for 2 years. So I'm not a super expert on Florida law, but he might have been able to solve that problem, by fighting the eviction. I don't know. But he decided to solve it with stabbing, which is not one of the legally recommended methods of solving disputes. Court records reveal that Edgar filed a complaint for unlawful detainer against his brother. The complaint in the case says that Edgar, on April 28th, revoked his consent for his brother to remain in his dwelling and informed him to demand he vacate the residence. A Broward County Circuit judge entered default judgment in the case. So apparently they did go through a formal eviction process, and apparently he didn't show up, which, is a problem. He could have shown up and perhaps resisted the eviction, talking to a competent landlord-tenant account lawyer, for example, maybe get some help, but apparently he didn't show up to his own eviction proceedings. So the judge entered default and issued a writ of possession commanding the sheriff to post notice of removal and remove anyone aside from the owner on the premise. So, they went to court about it. He could have fought about it and he didn't show up. So the judge is like, well, I guess I'm just going to issue the default. Post the notice on the door. You're hereby, you're hereby evicted. Don't come around here no more. But I want to come around here no more. And I have a knife. So knife apparently beats eviction notice, I guess. Thus, that brings us to the end of Donald Derby, pictured here in a little bit of dispute over a home. Apparently, there was some brother animus, unclear what. They had a 2-year relationship living together, and apparently something went wrong. And brother's like, you got to get out. He filed an actual legal proceeding. Brother didn't show up. Judge said, go away. And he said, but I don't want to go away. I want to be close to my brother forever. And I have a knife. And apparently someone called the police. They might have heard something unspecified. The police entered unspecified what their grounds for entering are. So maybe there will be a Fourth Amendment issue there, but we couldn't help noticing dead brother stabbed on the floor and you just lying nearby. So, well, on the unfortunate side, you will now be evicted from the home. On the fortunate side, you do have new housing options available to you, and they're exciting new fun housing options that are available to you that include a nice secure facility, free meals, lodging, 24/7 staff. It's going to be great. You'll never be alone again. And so that is the end of this case for the moment. All right. Let's see what else we got. All right, let's do another serious story. Let's do a kind of political story. Let's do a true crime story, and then we'll end with Florida Man for our stream for today. To the 173 of you who are here with me, I just want to say thank you very much for being here. Just a kind reminder, as always, that I do appreciate your support and your financial help of this channel. And we do appreciate super chats and new members and all the rest of it. So if you would like to hit the join button or hit the link told you by the bot or otherwise contribute to the channel, it is extensively appreciated. Thank you. All right, let's see what we got now. All right. Thank you, Contrarian, for the 5 gift memberships. They are appreciated. Thank you. In strangling is a strange way to show love news. A girlfriend has been locked up for life after strangling a man over loud music, praying, and taking a snooze. Well, you know, we do all have those pesky people in our life, sometimes who, you know, are doing things in a way that are disrupting our sleep or disrupting our quiet and peace. I certainly understand this is a problem, but there are ways to solve this problem, ma'am, that do not include the strangling. So please don't strangle someone for loud music, praying, and taking a snooze. Otherwise, you might wind up locked away for life. Let's learn a little bit more about this story. A Michigan woman who was convicted of strangling her boyfriend for 2 months to death over an argument of loud music was sentenced Tuesday to spend the rest of her life behind bars. So apparently the romance was not a long-lived one, just 2 months together. And apparently, you know, they had some incompatible habits, incompatible style. That does sometimes happen. You meet someone, you have an initial spark, and then you try to actually live with the person or, you know, get to know the person, and you realize that you have some conflicts in your life. It happens, but one of the ways to respond to this is not through the stabbing. Please less, or with the strangling, either way. Please less with the strangling, please less with stabbing. Just don't kill people in general, that'd be great. Ayana Mary Cullen, who is 23, and her defense lawyer said that she killed a 25-year-old man in self-defense, but the defendant also had a previous history of violence. So that's a bit of a problem, right? So we're using the prior history to show the absence of the defense, right? It's like, yeah, I did it for self-defense with the strangling. It's like, we can't help noticing that you have a history already at 23 of a bit of violence. So we don't believe you. So how would you like to, you know, spend the rest of your years behind jail, behind bars? You're 23. It's going to be a very long road. A probable cause affidavit detailed that the woman and the victim had been living together at their apartment for roughly a week when there was an argument over loud music that turned deadly. So, you know, fairly quick to move in with one another. 2 months does seem a little fast to move in with somebody. I mean, you know, it seems a little bit hurried, and they moved into each other and they found out they had incompatible things, and, you know, probably should have led to them being breaking up, but apparently it didn't. The suspect claimed during the argument she threw water in the guy's face and strangled him to death in self-defense, believing the situation to be life or death, which I suppose it was. In some sense, it was life or death. It just merely wasn't her life or death. She claimed that the man ran at her, dragged her by the hair, and choked her first to the point of blanking out. Authorities say the woman admitted to investigators she prayed over the body for more than an hour and cried before she knew for sure he was dead. Well, a little prayer and a little sorrow makes everything just all better. The woman then wrapped the victim's body in a robe, dumped his remains in a closet, and slept for hours on the guy's mattress, went out for a walk because she was tired of looking at him, and tried to wipe her fingerprints from the scene of the homicide at the apartment. I can't help noticing some steps here that seem a little bit incompatible with the self-defense theory. These seem like odd things for a person to do if it's self-defense. Wrap the body, throw it in the closet. I'm tired of looking at him. Just go out on a walk. Try to wipe fingerprints from the scene. Some of this behavior seems a little inconsistent with the self-defense narrative, ma'am. Apparently, it wasn't until the next day law enforcement learned about the killing, when the woman told her parents about it that morning. So apparently 23-year-old girl here calls mom and dad. Hi, it's great to hear from you, daughter. What's up? Well, I just strangled my boyfriend. It was self-defense though. And parents thinking, oh my God, self-defense, this is such a trauma. Let me call the police. Yeah, investigators found the guy's body while the woman was at the headquarters dying of mechanical asphyxiation. In other words, we garroted the guy, put a wire across his neck or something, choked him out until he died. Kalamazoo County prosecutors had contended with the fact that the judge had excluded evidence of certain admissions that they made to the police. So, dealing with that whole Miranda thing, right? So yeah, some of the things she told the police apparently not properly Mirandized, I guess. In the reported ruling, the judge noted the woman had twice asked for an attorney while down at the station, saying, yeah, just like I'm going to remain silent. So apparently at some point, she decided to speak up and ask for her right to an attorney or ask for her right to remain silent. So, everything past that point is going to be excluded. Everything prior to that point is fair game. But at some point she's like, I want to remain silent. I want an attorney. And the police kept talking to her. So the judge is like, yeah, I'm going to exclude all that stuff because she invoked her rights. Well, everything that she said before comes along for the ride. So despite the rulings and the self-defense claims, she was convicted in August by a jury of her peers of premeditated murder after 3 days of jury deliberation. While defense lawyers noted that she asserted the client wouldn't be alive if she hadn't killed the guy, jurors instead sided with the prosecution, where the defense lawyer himself had once worked as a prosecutor, which of course is not uncommon. According to the news, Kalamazoo County Assistant Prosecutor Amy Shepard said during closing arguments that Collin intentionally killed the guy. She did it because she thought about it, which, there's some evidence that certainly supports that proposition. The report said that the judge sentenced the woman to serve the rest of her natural life in state prison since the jury treated this as a third habitual offense. So she already has a record for the violence. So on top of the murder, 3 strikes and you're out. So yeah. So murder, how about life? Also, it's your third offense. How about life? So yeah. Michigan records show that the woman was sentenced to serve jail time after pleading guilty in March of 2021 and October 2021 in 2 separate assault cases, once against a police officer and another reportedly involving an assault on another man with a metal pipe. We can't help noticing this is your third violent felony, also with the murder. So how about 3 strikes and you're out? How about the rest of your life to the 23-year-old with the violence, with the strangulation, and also the assault on the police officer, and also trying to beat another guy with a metal pipe? She sounds like a delight. The judge says the jury disregards your defense and finds you responsible for the killing of the man, which seems likely. The attorney, for their part, said there was a substantial amount of evidence to support self-defense. Was there, though? Was there, with throwing the guy in the closet and going for a walk and not telling anyone about it for a day. And she apparently saying that she did it because she didn't like looking at the guy anymore. And also with the record of violence, was there substantial evidence of, self-defense? I'm a little bit dubious. The defense lawyer saying for their part, I am disappointed and surprised the jury found any evidence of premeditation to convict on first degree, let alone beyond a reasonable doubt. My client is exploring possible appellate remedies. Yeah, I wouldn't put out a lot of hope on that one. The jury is, of course, the finder of fact. So if there's any evidence at all, which there seems to be, just based on the story, like, the strangulation with the step afterwards and all the rest of it. Yeah, and the violence seems to undercut the self-defense theory. I'm not seeing a lot of rich appellate possibilities, but, you do you, attorney. Maybe you can find something. Thus, that brings us to the end of the story of Ayana Colon here, who apparently is 23 and going to spend the rest of her life behind bars because she strangled her 2-month-old boyfriend because they had a dispute over the loud music. Look, sometimes that romance doesn't necessarily pan out. Sometimes you just have massively different lifestyles. It's okay. But she decided to respond to it with the strangulation and putting the guy's body in a closet and going for a walk, and because she didn't like looking at the guy's body anymore, and so forth and so on, and also has a bit of a record of violence. And so the juries, somewhat didn't believe her, thought, premeditation murder looks pretty good to us. And then the judge is like, yeah, I can't help notice it's the murder and your third violent felony. So how about you go to jail for the rest of your life? So that will bring us to the end of discussion of this case. Fantastic. We had some more gift memberships. Sandy gifted 5 gift memberships. Thank you very much. Tony P gifted 5 gift memberships. Thank you very much. And Pierre Delecto gifted 10 gift memberships. Thank you very much for everyone who helps to support the channel. Your revenue makes this channel possible. All right, let's do another story. In the cult of transgenderism has taken another victim, but the victim is striking back news. A person who had their breasts cut off at the young age of 16 is now suing, saying, that wasn't really a good thing to do. I wasn't competent to make that decision. I didn't really fully understand the full consequences of what I was doing because I was 16 years old. And you took this action that rendered me permanently unable and disfigured. So striking back, not the first one of these lawsuits, and hopefully not the last. It's probably the only thing that's going to stop this is some of these people suing and suing successfully to get this thing to stop because of how reprehensible it is. So let's learn a little bit more about this case. At 16 years old, Miss Hine was at the time a minor when physicians from UNMC surgically removed her breasts in the first step of her so-called gender-affirming care, according to the lawsuit filed in Nebraska. The Center for American Liberty legal organization on Wednesday accused doctors at UNMC of lying to Miss Hine and her parents and of hiding research that doesn't support the prevailing gender-affirming model of care for people suffering of gender dysphoria. So the main attack here is on the informed consent, the informed part of the informed consent. The doctors lied to us. They hid information from us. They denied us information about studies that showed that there were problems with us. They denied us information that would have, tended to make us not want to do the thing. They only provided this information that said, this is great, let's hack off the boobs. And as a result of that, we did it. And so because you lied to us, because you withheld information, because you denied us the information, we weren't able to give informed consent. You lied to me and my parents, according to the lawsuit. According to the organization representing the woman, UNMC doctors deceived Luca and her parents with false promises, claiming if Luca did not undergo the removal of her breasts, she would take her own life, and unalive herself. So using that wonderful blackmail that we hear so much, if you don't do the thing, it will lead to the unaliving. The classic emotional blackmail. Do what we want, or else you'll have a dead child. Would you rather have a dead child or not? It's such emotional blackmail. It is truly reprehensible. According to the organization representing the woman, UNMC also concealed scientific studies that do not support surgical transitions for minors, including studies showing transgender surgeries actually increase self-harm and psychiatric morbidity. So, it's not all wonderful rainbows. And there's some real harm to some people, and you suppressed the information, and then you emotionally blackmailed us. If we don't do it, it will cause the unaliving. And then they're like, no, the studies actually to some degree show the exact opposite. So yeah. The girl, for her part, contends in her lawsuit that doctors and healthcare team at Nebraska Medicine were negligent by not questioning her self-diagnosis and instead affirming her gender identity per a prevailing protocol known as the Dutch Protocol. So they didn't even challenge me. They didn't even question me. They just took it as acceptance. They just took it as true. And they didn't even attempt to try to stop me. They didn't do any psychiatric evaluation. They just said, yep, let's hack off the breasts right away. So that is what they did, and also denied us the information to make an informed decision. The woman claims that this decision caused her harm, encouraging totally irreversible chemical and surgical solutions. The Dutch protocol, which apparently the hospital was using, is the origin of the gender-affirming model of care, which Hines' lawsuit contends conditions children towards transgender identification by encouraging social transition, chest binding, opposite sex pronouns, cross-sex hormones, and surgery, rather than treating the underlying gender dysphoria. So no attempt to treat the underlying mental health, right? Let's just go straight to the surgeries. Let's just hack off some things and give you some chemicals. No need to treat this as a mental condition whatsoever. We'll just give you the surgical and the chemical treatments. In a post on Instagram earlier this year, the woman, who was 16 at the time, describes herself as a victim of gender-affirming care by saying, quote, "I was a young teenager with a history of mental health issues who had been groomed and preyed upon online, and as a result fell into a spiral of hatred towards myself and my body. The medical system did not look into or seem concerned about the underlying issues that were causing the distress that made me feel the need to escape my body at such a young age," she writes. "Instead, I was affirmed down a path of medical intervention I could not fully understand the long-term consequences of due to my age and underlying mental health conditions, which apparently they did nothing to treat or even examine." The lawsuit contends that by immediately affirming her, the doctors developed a type of transgender tunnel vision that blocked out many factors that were or could have been causing the underlying dysphoria. So, don't think about it, just do the surgeries, just do a path, no one questions it, everyone's just, chewing along, no muss, no fuss, no need to examine the underlying mental health. Didn't really get a full quality of medical care. The treatment method of affirming the so-called new gender identity is now bitterly regretted by the woman, and she says came to a period of her life when she was undergoing profound personal upheaval, trauma, and distress, according to the complaint. "You took advantage of me in my weakened condition and just put me on a path towards a resolution without any concern the fact that I was mentally distressed." Ms. Hine, the suit claims, was simply too young to understand the irreversible implications of the transgender treatment recommended, prescribed, and carried out by UNMC because she's 16. And, and she was, mentally disturbed and mentally troubled, and she wasn't in a position to consent. But they're like, yeah, so you took advantage of me. The defendants, for their part, the UNMC physicians and Nebraska Medical Center, are controlled affiliates of co-defendant Nebraska Medicine, which coordinates and controls activities of the two entities, including inpatient and outpatient hospital and physician care. The clinic is based in Omaha, in Nebraska. The lawsuit specifically names Dr. Nahir Amora, a OB-GYN and director of the Gender Care Clinic. It also names Dr. Perry Johnson, a plastic surgeon at the Gender Clinic, and Dr. Stephen Barantinos, a resident physician who allegedly assisted Dr. Johnson in removal of the breasts on the alleged advice of Dr. Amora. Megan Smith Salins, a mental health therapist working in gender care, was also named as a lawsuit as working with the three physicians to cause the actual harm. Ms. Hines' complaint contends the physicians at UNMC, a clinic that boasts about its leadership in groundbreaking research, had both the ability and duty to independently examine the scientific basis of the gender-affirming model that they were using. So they were just, taking this and running with it without thinking critically about it. They weren't using their brain parts. As Nebraska's premier medical institutions and with millions of research dollars at hand, defendant owed a duty to the woman and hundreds of patients like her to independently research the underpinning of the Dutch study before adopting its flawed protocols, according to the complaint. The lawsuit contends the Dutch model should never have been used as justification to scale up the protocol for general use. But like a virus that escapes the lab, the Dutch protocol spread like a contagion due to a runaway diffusion, a phenomenon whereby innovative clinical practices are rushed to market without long-term, carefully controlled ethical research demonstrating the benefit outweighs the risks. So a bunch of people took this, they took it prematurely, they started running with it, and have caused some actual harm in the real world when they were in a position to actually, look at it with more care and caution before doing harm to a patient. The lawsuit claims that the seismic shift away from the time-tested protocols in diagnosing patients meant that the reasonably prudent doctor had a duty to examine and assess their patients for other potential causes of stress before reverting to irreversible procedures like double mastectomy or hysterectomy, according to the complaint. UNMC's website boasts that it's earned the top performer designation from the Human Rights Campaign, a group that lobbies for the Dutch protocol. So, they got all their accolades from their woke friends at the risk and expense of their own patients. This means that UNMC staff do not question a patient's self-diagnosis or gender transition, no matter the age or whatever root issues might be causing them to suffer. Rather, UNMC faculty affirms the chosen gender identity on the patient and then undertakes pharmacological and surgical interventions based on the Dutch protocol. The Dutch protocol received its early support in the early 2000s and has become a prevailing treatment method for gender dysphoria within the United States. But multiple follow-up studies have pointed out its weaknesses because, maybe just accepting what someone says about themselves and not undergoing their psychology at all, maybe that's a bit of a problem. Maybe you should, look and examine about their mental state before just saying, yeah, I'm a girl or I'm a guy, as the case may be. Let's hack off some bits. Just merely you say it, we take it at full face value without any examination whatsoever. I mean, I'm not a doctor, but that sounds really stupid. So, yeah. Ms. Hines' complaint contends the study had no control group. The study cherry-picked patients. The study ended with 40% of fewer patients participating, one patient dying from complications, and the study excluding data from patients whose treatment with pluggy property blockers didn't progress well. So the study itself was corrupted, which, anyone with a medical degree should have been able to figure out. The complaint also notes that the studies themselves were funded by the pharmaceutical industry, which provides puberty blocking drugs and stood to profit from favorable results. So the company that blocked that, that did the study, that became the Dutch study, also happens to produce puberty blocking drugs and might have financial benefit. What are the odds? Money-based incentives? In my medicine, it's more likely than you think. Excuse me. Thus, that brings us to the end of this article about a woman suing for undergoing the transitioning care because she was 16 at the time, not competent, not fully informed, led down the primrose path, and now has suffered irreversible damage to her body. Not the first lawsuit like this that we've seen. We begin to see a couple more like this. We've covered a couple of these recently on the channel. And I think that in the end, this is probably the only thing that's going to stop this madness. A lot of states are trying to get involved. A lot of states are trying to prohibit this. But, the lawsuits which are going to prohibit this are going to be probably the only thing that ends it in the end. So I certainly like seeing more of these lawsuits because this kind of care is some bullshit and it should be treated as such. And that is where things are going. And at least for a moment, that brings the end of discussion of this story. Yeah. You know what I've been forgetting to do this whole time? I forgot to push the button to change the lights. God damn it. God damn it. All right, let's end this with Florida Man. Thank you for the $10 ever cuber. I just kind of forgot to put on my hat. I didn't really even think about it. I just forgot to put it on. So it's going just that well for me. All right. Let's wrap this up with Florida Man. In today's Florida Man story, a man from Hollywood, Florida, is accused of torching the car of his then girlfriend, who also is his cousin. So a little bit of familial and dating discord going on in Florida, resulting in torching cars. Very dramatic. Let's learn more about this story. Miami-Dade police arrest the 37-year-old man from Hollywood, Florida, accusing him of lighting a car on fire back in April. Police say the car belonged to Melvin Allen Clinton's then girlfriend, who also was his cousin. Gonna make the family reunion a little bit more awkward, I would think. According to arrest reports, Citron was caught on camera April 29th lighting the Jaguar XC sedan on fire in front of the home of Northwest 120th Street and 5th Avenue. Police also say he left his cell phone behind, which was a bit of a clue. Who could have ever done it? Well, we can't help noticing the guy's cell phone is right there by the car. Police say that they determined soon after the vehicle belonged to Citron's girlfriend and cousin, but weren't able to interview her until Monday after failed attempts to contact her over subsequent months following the crime. She said she initially lied to investigators and told them the car caught fire as she drove home because she feared reprisals from Citron, who made her put the phone on speaker whenever she spoke to investigators, according to a report. The woman told police she fears Citron in part because he regularly carries a fully automatic gun with double drum high capacity magazine, which he told officers he refers to as the gun's tits due to the 2 round drums on either side of the magazine. Wow, this guy sounds special. Okay, so he has a double drum magazine and calls it the gun's tits. Okie dokie. It's going great over here in Florida. She also told police that Citron stole her purse and left her stranded at Miami Bayside's Marketplace Friday after the two got into an argument because he thought she was flirting with the bartender. The purse contained numerous items, including $1,200 in cash, according to police. After issuing a warrant on Monday, police say officers later located Citron outside of a business east of Hialeah and arrested him at gunpoint on Wednesday. As of Thursday afternoon, he's being held in the Turner Guilford Night Correctional Center on $12,000 bond of charges of second-degree arson and third-degree grand theft. Thus, that brings us to the end of the story of Mr. Citron over here, who apparently dating his cousin, and things are not necessarily going well with, lighting the cars on fire and all the rest of it and being charged with the second-degree arson. So unclear how this Florida love story will come to a resolution, but we will see. And that, for the moment, brings us to the end of discussion of this story. Well, my friends, that will bring us to the end of the stream. I hope you had fun. I had fun. Thank you, Sandy, for saying I look handsome. That's very nice. That's very nice. So, yeah. So, all that good stuff. Let's see. No one is streaming except Recovery Addict. I don't know what he's covering over there, so I guess I want to redirect you today. But we will be back tomorrow with more Uncivil Law. So until then, my friends, I hope all is well. And we'll go from there. All right. Until later, my friends. Bye.